premise question. In other words, it is a little bit of an unusual posture that we had a full trial and we had a jury verdict. So we don't even get to this line of immunity discussion if there were no suspicious circumstances. And my question to you is, how is that not a disputed issue of fact if the jury verdict itself said, by engaging Special Agent Vahi's assistance, did Delta make a voluntary disclosure of any suspicious transaction? No.
A few things. They first said yes, and then about 40 minutes later, they answered no to the same question. There's a conflict. There's inconsistent evidence. Besides,
but if there's inconsistent evidence, that's the end of the game for you.
Well, no, this is an issue that never should have gone to the jury in the first place. The jury never got the proper instruction, which under Air Wisconsin is when in doubt report.
Okay,
that's
but
standard.
This is getting, now you're trying to impeach the verdict. I didn't see that in the briefing here. We had a trial and we have a jury verdict that's checked no suspicious circumstance. You're saying there is no material issue of fact the opposite way?
There is no material issue of fact. First of all, the jury had two inconsistent verdicts. Second of all, this is an issue of immunity. The issue of immunity should have been resolved at the earliest possible stage under the proper standard, which is when in doubt report. Mr. Bandary is someone who not only took pictures of flight attendants, but paced around the plane, not just to go to the bathroom, but in his words, he walked around a lot because he's a walker. He scared passengers who thought he was a terrorist. He scoped out
right, but that's such disputed testimony. Cook herself said, I didn't say it. Rudmeyer, whatever her name is, seems to have different viewpoints of it as to whether he was suspicious. To me, it's trying to go to the bathroom several times and a photograph.
Your Honor, the Supreme Court said, when in doubt, report without hesitation. Do so.
The difficulty here is we have a trial and we have witnesses that have said there wasn't suspicion beyond a man needing to go to the bathroom a lot. And then we have a jury verdict, which you may be saying is an inconsistent verdict. But how do we just assert ourselves there's no issue of fact when it seemed like through trial to verdict, there was a direct issue of fact on suspiciousness?
The jury was not asked the right question, which is, was there room for doubt? The standard is when in doubt, report.
And you objected to the jury instruction?
We did not object to the jury instruction, but here we're not reviewing the jury instructions. We're not reviewing the jury.
I know, but now you're telling me we can just ignore that because you're saying it's invalid because it was an improper instruction, but you didn't object to the instruction.
What I'm saying is this.